Hello, everyone. Welcome to today's session on the new 482 visa. I hope you can all hear me. I understand there's been a few challenges with the meeting session starting and then finishing. I hope you've all managed to find your way back. Today, we'll be talking about the new skills in demand visa. There's quite a few things to cover, so we won't necessarily cover everything in detail, but I'll certainly try and make time at the end to answer any questions that people may have. Now, what I'll do is I'll just share my screen. So bear with me 1 second. I think we're probably all used to the fact post-COVID that webinars are not exactly live television. So please excuse any momentary delays. I would love to have a production team here to help me, but unfortunately it is just me today. So thank you all. Can you see the screen there with the presentation? Wonderful, thank you. Just looking for my my chat screen. So the skills in demand visa came upon us rather quickly. I certainly didn't expect it after the legislation didn't pass Parliament in the last week of November. I planned a holiday for myself, only to find out that the department decided not to let legislation stop them from implementing the new changes. As a result of the legislation not coming through, what has effectively occurred is that the department has looked to implement the visa, but some of the major changes that they wanted to make have not occurred. And what that means is that we will see additional changes through 2025 once the government, if the government manages to pass the legislation. Now, I've just gotten a message that chat is disabled. Attendees can chat with everyone, and I think that should be good to go now. So if you want to send a test chat or a test question, please feel free. We will see changes through the next year. Thank you very much, everyone. The chat is working. We will see changes through the next year because some of those key pieces that the department wanted to put into place, such as ensuring the indexation of the minimum salary thresholds are embedded in legislation, haven't gone through. Now, the government wants to put those in place because I believe there is a concern that should there be a change of government, the Liberal Party would not look to index the remuneration. So by embedding that requirement in the Migration Act rather than the regulations, it makes it much more difficult to achieve. And we can see from the fact that the Liberal Party didn't index for 10 years, and then basically when Labor's come back into power, they have gone back and done a 10-year update. The Labor Party considers that to be a really critical part of the program, and they want to see that remain in place because there's a lot of concerns there about undercutting local employment conditions and the potential for temporary overseas visa holders to perhaps undercut local labour market conditions, which is very much against the intent of the policy, at least as it's seen through the eyes of the department. So what we'll be covering today is very briefly, some background to the changes. We'll be looking at the new skills in demand streams because the previous program had 3 streams. 2 of them have been removed, and we've got 2 new streams which create a different framework. We'll be looking at the changes to the nominations in all streams. So we'll look collectively, then we'll look at the streams in some details. We'll look at changes to the visas, as well as the impacts that all of these changes are going to have on pathways to permanent residency. And we'll briefly touch on some unresolved issues. I was looking this morning, and I think one of the indications of a rushed change really is the number of legislative changes that we see come through. So what we've actually had over since the 6th of December, so that's 12 days ago now, is 1, 2, 3, 4 different sets of regulations. And that just goes to show that the department really has pushed these through in a rush. They haven't been fully vetted before they were implemented, and there's needed to be a number of rushed changes to fix things. It may well be that there are more changes to come because, as we'll discuss in the unresolved issues, there are a few items that really remain unaddressed that will need to be looked at in more detail in order for people in the migration profession to really give completely certain advice in some of these areas. And we'll touch on that. So, background to the changes. Temporary work visas have been an increasing phenomenon for the last 30 years or so. From World War II until around the mid-90s, Australia was very much a nation governed by permanent migration. People applied to come to Australia. They came as permanent residents. They settled with their families, and they were here for the remainder of their life unless they chose to, move elsewhere. Since the mid-90s, we've seen a rapid increase in the number of temporary migrants in Australia through programs such as the temporary work visas, but also through student visas and other means. And we're now in a situation where there's around 2 million temporary visa holders in Australia at any given time. Okay, so it's a very different environment than it was 20, 30 years ago. And the government has a great challenge in managing the way that temporary migration works. It is uncapped, which means that people are basically coming in based on demand, whereas the permanent program is a capped program at around 180, 190,000 people per year. Now, if you've got 2 million temporary visa holders in Australia now, and you've only got 190,000 places each year, you've essentially got 10 years worth of people in the country at any one time. And the government has to look carefully at how and who they let into permanent residency. And we'd all be quite aware, I believe, that in Australia, this is really based around economic benefit to Australia. There are countries out there that do not manage it this way. Their primary concern is not around, maximizing economic benefit, but that is very much the way it is in Australia. And it's in that context that the temporary visa programs have played such an important role in enabling people to come into Australia, enabling employers to fill roles. Now, the thing about temporary visa programs, temporary work visa programs is, despite the fact that the government announced this as the biggest migration change in a generation, what we've seen is that many of the changes are not revolutionary. They're not radically different. They are an evolution rather than a revolution. And I believe that the reason behind this is really because the Department of Home Affairs does not know a better way to do it. Okay. And that is not to put down the department, but rather Australia has long been considered a leader in the field of innovative migration programs aimed at, economic benefit. We're in that sort of top cohort in that regard, along with countries like Canada and New Zealand. And we don't see, as a country, as a collective, as a government, a better way to do this. Okay. So a lot of what has occurred is really fine tuning. That fine tuning will result in some significant changes over time, but the program is largely the same. There are streams, there are visa occupations, there are classifications. These things will remain. I think the main thing that will change is really the detail. Okay, so moving through the visa programs to 2024, we've now moved to this skills in demand visa. You'll note that the visa subclass remains the same, so it is still a 482 visa. It's just a new iteration of the same visa. One of the reasons that I believe that that has been done and that visa subclass has been retained is to ensure some easier interaction between those types of visas. So When we had the 457 visa to the 482 visa, there were a lot of changes that were required to ensure that people who had 457 visas could easily access the 482 program. I think the government has tried to simplify that this time by retaining the same visa subclass. And you'll note as we go through that in a number of these situations, the government has tried to maximize the ability of people who have existing 482s to apply for new 482s. There are limitations to that. There are some specific limitations that we'll touch on, and there are some gaps that perhaps remain unaddressed and will need further clarification from the department. But even though the changes may seem simple on the face, when you go and you look at the legislation, you look at the changes that have been made, there is a lot of detail there. And that's why sometimes there are gaps in these programs. If anyone recalls the change from the 457 to the 482 program, one of the things that happened was there was a number of occupations that were removed and were no longer eligible under the 482 program. And the government did not at that time implement any type of transitional arrangement or grandfathering. So people who had applications that had been lodged for 3 months, 4 months for a particular visa, all of a sudden there was no pathway for that visa to be approved. They were refused. They had no route to appeal because there was just simply no visa available for them because of their occupation. That situation has not been replicated here. The government has tried to ensure that there are pathways available in most circumstances. So, looking at the streams, we previously had 3 streams under the 482 visa. You had at the top of the hierarchy, if you want to classify it that way, we had the medium and long-term stream. This was for occupations that the government considered were of the greatest long-term benefit to Australia. And when the 482 visa was implemented, this was the only one that really had a guaranteed pathway to permanent residency. Okay. You had lots of doctors, nurses, IT professionals, okay, but not a lot of white collar roles. The short term stream was for occupations that were deemed to be in need in the here and now by employers in the labour market, but they were not necessarily roles that were needed long term in Australia because we had the capacity as a nation to train people and fill those roles. There were a lot of white collar roles on that list, sales and marketing, just different business roles, okay? And they did not initially have a pathway to permanent residency. That was changed when the Labor Party came into power. And there was a shift to allow those people to remain in Australia. But there were still some challenges around that, okay? And I'll touch on those a little bit later. What we've seen is that the government has removed those 2 streams. Short term as well as the medium and long term are now gone, and the labour agreement stream remains. Okay, so the labour agreement stream is for all of your visa applications that are outside the normal framework. So if you wanted to nominate an occupation that was not on one of the skills lists, then you would be looking at the labour agreement. If you wanted to nominate people who may not have the necessary English language skills, it was the labour agreement that you were looking at, and you would either negotiate with the government on a company by company basis, or there were industry agreements that had been agreed with peak bodies, such as the pork industry, the fishing industry, various others, where there were a defined set of terms and conditions where you could engage a dairy farmer or a dairy worker under a specific framework. That has remained in place, okay? And we won't touch on it in great detail, but we do expect there to be more changes to the labour agreement program in the future. What we've got in place of medium and long term and short term is a new specialist skills stream and a core skills stream. Okay, so we still have a hierarchy. The specialist skills stream is the better stream, okay, and I'll go into why before, but a bit later. The core skills is largely aligned to what we would have called the short-term list previously, in the sense that the government has done a detailed review of the labour market. The Department of Home Affairs requested Jobs and Skills Australia to go out and look at what roles are needed in the economy, in terms of training shortages, in terms of high turnover, in terms of the length of time it takes to train people in these particular occupations. And what they did was they prepared a list of occupations. There's 456 occupations on the list, I believe, and those are occupations which are eligible for that core skills list. The specialist skills, to go back, does not require you to nominate an occupation that is on a list, but it does require a remuneration far higher than the core skills list. So if you've got someone who doesn't neatly fit into one of those occupation boxes and they'll be receiving above $135,000, that is not an issue at this point. Okay, you'll be able to find a visa pathway for them. But for people who are in that bracket between 73,150, which is the minimum income for the core skills, as it was for the 482, and 135, you have to fit into one of those boxes. And we'll talk a bit more about that. So both the core skills and the specialist skills streams have common requirements. They have common requirements that are shared across both, and then they have individual requirements that you must meet based on the stream itself. Now, to talk about those common features or common criteria first, what we've got is the duration. Under the previous program, you had visas that were eligible for either 1 to 2 years in the short-term stream or 1 to 4 years in the medium and long-term stream. Okay, so short-term, medium and long-term really did correspond with the actual duration of the visa. Now, under the new program, all visas under the specialist skills and core skills will be available for anywhere from 1 to 4 years, with a weird little exemption for Hong Kong nationals, okay, which originally comes from the fact that Scott Morrison wanted to poke the Chinese government in the eye. You got the 5 years for Hong Kong citizens, and what you'll find is that Hong Kong citizens will actually be granted a 5-year visa even if you don't ask for one, okay? But now, under the new program, the new SID visa, all visas will be eligible for up to 4 years. There was discussion previously of revising the way that the government would be billing for these visas. When an employer lodges a nomination, they're required to specify the duration. So it's the employer that gets to set the duration, not the visa holder. And they're required to pay an annual fee, which varies depending on turnover, for each year they want to sponsor. So if you've got a turnover under $10 million and you sponsor for 1 year, it's $1,200. If you want to sponsor for 4 years, it's $1,200 times 4, so it's $4,800. That system will remain in place for the time being. There has been discussion about the government moving to a system where people are paying on either an annualized basis or another regular basis. So rather than paying $4,800 up front, you would be paying $1,200 per year while the person remains employed by the organization. That would be a very beneficial change for employers, because there are definitely scenarios where people apply for a visa with a longer duration, but the employment relationship does not work out, and the person then moves on and the employer has paid a significant amount of money and does not have the ability to get a refund. But two things. Before this system is possible, firstly, the legislation needs to pass. And secondly, what we will need to see is an actual implementation within the Department of Home Affairs that allows them to bill in this way. Because as far as we're aware, there is no machinery behind the scenes that would allow the department to bill on, a subscription or an annualized basis. Okay, so even when the legislation passes, if the legislation passes, there are a number of major fixes that will be required behind the scene before that is possible. So it might happen, but it could take 6 months, 12 months, who knows? Work experience. Work experience has been reduced from 2 years full-time to 1 year full-time. And the reason behind that appears to be that the department or the government really wants to give people the opportunity who study in Australia, do a graduate visa in Australia, to easily transition through to a 482 work visa. And by reducing the period of work required from 2 years to 1 year, it makes it much easier. Some of the graduate visas out there, for example, only allow for 18 months. So it's essentially impossible to accrue the 2 years required during the graduate visa period. And that puts these people in a very difficult position where they've obviously paid for their education in Australia, they've obtained a graduate visa, but they're blocked from a pathway to permanent residency. This is an effort to fix that. But it also does a couple of other different things. It puts the 407 training visa under a bit of a question mark. The training visa allowed organisations to sponsor people for a period of up to 2 years to gain work experience or to access registration, for example. But in order to then access that training visa, you needed to have already done 12 months work. Okay, so if you need 12 months to do a training visa, but you also only need 12 months to do the 482 visa, there is a bit of a question there about how those two things will relate going forward. We've also seen a reduction in the work experience. We've also seen a change to the requirement for when the work experience is needed. Previously, that was unclear in the regulations, but what has happened is that the department have now specified that you will need to have done the relevant work experience in the last 12 months, okay? The last 5 years. My apologies, I'm getting distracted because I noticed that my camera is not quite pointing in the right place. Work experience will need to be within the last 5 years. That is now going to be embedded in the regulations, and what it does from the department's perspective is it ensures that people have the relevant skills and experience to do the job. What it does for employers, however, is decreases the pool of potentially available talent. We've seen situations, for example, where someone may have been a registered nurse more than 5 years ago, but since that time, they've been doing another job in the hospital, and now they want to be sponsored to apply to work in Australia as a registered nurse. Previously, it was arguable that they had the skills and experience to do that. That argument is now no longer feasible. Okay, you need to be able to demonstrate at least 1 year in the last 5 years in order for this to work. English language threshold has increased slightly from the short-term requirement. Both streams now require an equivalent of IELTS 5.0. The short-term stream had some greater flexibility around that. So that is a minor change, but it will impact some people often in the trades who do not have the same level of English as people who've been to university in English or things like that. So it's something to be aware of if you do tend to employ people in the trade sector, because it will potentially affect some of those candidates that are coming into your inbox and whether or not they're going to be eligible for this visa. Changes to the minimum income threshold. So we've long had, since about 2008, I believe, we've long had this acronym TSMIT, Temporary Skilled Migration Income Threshold. The idea is that this is the minimum amount of money that a temporary visa holder, a temporary work visa holder should be earning, okay? And quite infamously, it was sort of stopped there at 53,900 for about 10 years before the Labor government came in and indexed it up to 70,000. It's been indexed, I think, once since then to 73,150. What's happening is that the core skills will remain at that same threshold, and the specialist skills will be set at 135,000. Okay, that's the starting point, 135,000 plus super. Now, the government has not managed to embed the indexation in the Act, but they have placed it into the regulations, which means it will occur. But if there is a future government, it could be relatively easily removed. But the other impact is that we will see those minimum thresholds increase by the average weekly ordinary time earnings, which is a figure that the Australian Bureau of Statistics tracks. And the idea is that these are supposed to be skilled roles, and people who are below these salary thresholds are not going to be eligible for the 482 visa in these streams. That is what the labour agreement stream is for. Okay, so if you have remuneration below that level, then within your industry, then you're going to be looking at labour agreements, and we'll touch on that in a little bit. Condition 8607 requires the visa holder to only work for their sponsoring employer. There was a change in the last 6 months where the government increased the flexibility there, was their language. The idea being that they were essentially creating giving temporary visa holders greater flexibility to move between employers, and that would prevent exploitation. I think the unstated reason there is also that temporary visa holders become a much more closely aligned with the other players in the labour market. And what I mean by that is that, if you've got very low unemployment and you've got temporary visa holders who are no longer tied to a specific employer, then they can shop around and they can go to other employers with better terms and conditions. And so it not only has this effect on the exploitation and enabling people to get away from exploitative situations, it makes temporary visa holders in this situation able to negotiate better terms and conditions potentially, and is going to act as an upward pressure on salaries. And it's been very obvious from the Labor government since they came to power that that is one of their intentions. They don't want to see salaries suppressed by temporary visa holders. And I think that this, in many respects, is one of the efforts to do that. Important to note that when a temporary visa holder is with the sponsoring employer, they have an obligation to make sure that person only works in the specified occupation. And what I mean by that is that they are required to only allow the temporary visa holder to work in whatever occupation was listed in the nomination. So if the employee is listed as a software engineer, they're not allowed to go off and be a project manager. They're not allowed to go off and be a dentist. They can only work in that occupation. And it was a requirement on the employer that if they did not make sure that that was the case, then the Department of Home Affairs could sanction them, because this was one of the sponsorship obligations. Now, that obligation effectively became either redundant or impossible to enforce when the government created this new flexibility that would allow temporary visa holders to move between employers. Okay, so now that this greater flexibility is in place, the government is saying, well, your obligation is only limited to the duration of time that they are employed with you. Okay, which is obviously common sense. Previously, before the change to 8607, when a temporary visa holder ceased with their employer, they had up to 90 days, 60 days, it has varied over time, to go and find another sponsor, but they weren't allowed to work. By allowing people to work during that period, the government is saying, well, this is a scenario where, someone leaves an exploitative employment relationship, but they're unable to find a job in their sector. They can go and they can get a job working at a petrol station or picking fruit or doing whatever to support themselves, because they don't have access to unemployment benefits or anything like that while they seek another employer. Okay, so that's the change here. The flexibility has been retained from what the government did about 6 months ago, but they have removed that sponsorship obligation. It's a bit of a game changer for employers because the um, the way that the employment sponsorship has worked in the past is that there is a very close link between working for your employer for an extended period of time and access to permanent residency. And this change, along with a couple of others, mean that that relationship is nowhere near as tight as it used to be. We'll come to that when we talk about the 186. Visa application charges. So previously, the short-term visas had a lower price. Core skills were at the medium and long term list was at the 3,115 figure, okay, and the short term stream was at a lower figure, I believe about $1,700 or thereabouts. Now, what has happened with the change is that the government has effectively removed that lower visa charge rate. And, without wanting to be too cynical, it's pretty typical of government to do this sort of thing. They're not going to lower their prices. This is a major revenue stream for them. And now that the visas are all available for up to 4 years, there was no real reason that the government was going to reduce the amount of money. It remains a little bit ridiculous, and it was ridiculous before because you can get a 1-year visa and it's going to cost you $3,000. You can get a 4-year visa and it's going to cost you $3,000. Okay. So for visa holders, longer visa periods are obviously much more beneficial than a short visa period. But the same is not, that is not necessarily the same in terms of incentives for employers. As mentioned before, both streams have access to permanent residency now. And there is an additional requirement that has been entered in there that the employer must be able to demonstrate financial capacity to employ visa holders. That was not necessarily present in the 482 nomination or visa criteria previously, but it has been a requirement within the 186 and in some respects in regards to the sponsorship agreement. Okay, so employers, when they went to apply for sponsorship, they would generally demonstrate their financial position. Similarly with the 186, when you said, we're going to offer this person 2 years ongoing, you needed to put out evidence that you have 2 years, the ability to fund that. And this has now been applied to the 482. For larger organizations, this is unlikely to be an issue. If you're a public company, if you're a government entity, it's not so much of an issue. But if you're a small and medium business and you've posted losses in the last 12 months, this can create some real challenges. And it's something just to be conscious of. It's not uncommon for small businesses to suffer a loss in a year or 2 years in a row on the basis that they've had positive financials in the past and they expect to return to positive financials. However, the department doesn't necessarily see things through the same lens, and it's important to understand what sort of evidence you're going to need to give to demonstrate that. Now, just a few updates to the labour agreement stream. The government has introduced additional regulations here. That really just means that there is additional detail in the regulations. Previously, a lot of the labour agreement program was really governed by a couple of very limited provisions that said something along the lines of the minister has the power to enter into a labour agreement. Okay, and then it sort of left it there. And so the labour agreement stream was largely outside the regulatory environment. It was a creature of policy, if you will. The government had its approach, it had its standardized documents and all this sort of stuff. That will still continue, but a lot more of the information about how the process works is now embedded in the regulations. And my belief, and I think it's shared by a few people in the industry, is that this is really around creating a stronger framework for increasing the number of labour agreements in this space. Now, if we talk about that, the government has recognised that there is an increasing need in some of those lower remunerated occupations that is not being met within the Australian labour market. And this includes things like the aged care sector, disability support, childcare, and other industries such as that. But the government is trialling the aged care labour agreement, which is a tripartite agreement, meaning that obviously the government is the decision maker, the employer is the applicant, but you also have direct union involvement. It's not a matter of the way things used to be, where you would send a letter to the local union, to the relevant union, and say, hey, we want to sponsor people. In fact, with the aged care labour agreement, you've got to enter into a memorandum of understanding with one of the relevant unions, depending on your sector and your geography. If Labor remains in power, it is highly likely that future Labor agreements will be done much more on this tripartite basis. The government is trying to get unions more involved, and the belief is that if they do so, then there is less risk of exploitation, because there's a pretty direct correlation between the level of remuneration and the likelihood of exploitation within the temporary visa program. You know, there's not too many medical practitioners on 300,000 running around claiming exploitation, but there are quite a few people who are in, you know, the farming and agricultural sector, and in some cases in hospitality, aged care, things like this. It's just a statistical reality, and this is, I believe, the government's attempt to address that. If anyone has any questions, please feel free. I believe they are enabled. Yeah. Now, we mentioned the grandfathering. That's another way of describing those sort of transitional arrangements. Where a 482 TSS nomination and visa were lodged prior to 7 December, they will continue to be processed as usual according to the rules that were in place at the time they were lodged. Where a nomination has been lodged before the 7th of December and remains undecided, or remained undecided as at the 7th of December, it will be considered under the existing rules, but it will allow for a new SID 482 visa to be linked. So you'll have an approved 482 nomination, might even come through as an approved SID nomination, and you'll be able to apply for a 482 visa. And my understanding is that this includes occupations that are no longer on the consolidated list on the basis that there is an approved nomination that was approved, that approved that specific occupation. Okay. That is very distinct from a scenario where someone is in Australia, they have a TSS 482 visa, and the occupation that is listed, is nominated in their visa, has been removed. This is probably the cohort who are going to face the most difficulty. Okay. Example being restaurant manager. It's one of the questions that's come up time and time again in discussions to date. Restaurant manager was a very highly used occupation, and it has now been removed. Where people are ceasing employment, they will not be able to transfer to a new sponsor. Okay. And that's just brutal reality. Unless they qualify for the SID visa or a labour agreement application is made. Okay. So because the new skilled occupation list only applies to that core skills stream, there may be a pathway through a labour agreement below, you know, in the hierarchy that we've got below the core skills or above it. Okay. But that is very limited. And obviously, there will be quite a few people in a difficult situation. One of the other related difficulties that we will see in this area is for people who were granted visas under that short-term stream we talked about before, because it was only valid for 2 years. Now, if you were granted a visa on the 1st of January as a restaurant manager, let's say you were granted the visa on the 1st of January, 2023, and you arrived in Australia on the 1st of February to start the job. You've worked every day since then, and you want to apply on the 1st of January 2025 under the temporary resident transition stream, which requires 2 years full-time work. That is not going to be possible because you missed a month at the start. You'll only ever get to 23 months, not the 24 months required, and you won't be able to apply for another 482 visa, okay, unless it's in that specialist skill stream. The impact of that is that there will be people in Australia who've accrued work experience but won't be able to meet that 2-year requirement. And the discussion has been so far that essentially your options are find another visa or go home. And unfortunately, there are always winners and losers in the Australian immigration system, and there will be impacts. Okay, so what I would encourage everyone to do is look at your organisation and see what are the occupations that have been removed. Will anyone in my organisation be in this situation? Are there alternatives such as a labour agreement or that specialist skills pathway? And certainly, if you want to reach out to us for discussions on that, we'd be more than happy. It is obviously a really critical issue for organisations trying to retain their workforce and, of course, just simply support employees who are in a difficult position. Stream-specific requirements. So the core skills stream is operating on the basis of this new core skills occupation list, or CSOL. 456 occupations. By my count, around 95 occupations were removed, but about 100 occupations were added. Okay. Now, one of the things about the occupation removal and the occupation additions is that we also had an update from the relevant jobs dictionary that we use for immigration purposes. Now, that jobs dictionary I'm referring to is the ANSCO, or Australia New Zealand Standard Classification of Occupations. It's basically a dictionary developed by the Australian Bureau of Statistics to classify all the different jobs in Australia. It was never particularly intended for use in migration, but it has been used in migration for at least 20 years now. And the result of that is that that list was 11 years out of date. It had a lot of things missing that are very common jobs in the local labour market now. And so the government has moved to this 2022 updated edition of ANSCO. That means that new occupations were added, such as 6 new cybersecurity roles, data scientist, that was meant to be data analyst and scientist, regulatory affairs manager, and so forth. But it also meant that some occupations just changed for purely administrative reasons. Occupations were revised and given a new code. Okay. Now, you would like to think that common sense says that, if someone's occupation code changes but the job doesn't, then it's a pretty straightforward fix. That's not necessarily the case, just due to the way that the legislation works. ANSCO, so I've just received a question there. ANSCO is now replaced by OSCAR. That is correct for the purposes of the ABS. Okay, so essentially Australia and New Zealand have gone their separate ways on the jobs dictionary, and Australia has now developed its own called OSCAR, OSCA, but the Department of Home Affairs has always been several years behind where the Bureau of Statistics is with these editions, and we are only just moving to the 2022 edition of ANSCO. So if you're looking at occupations, it is that 2022 ANSCO edition that you should be looking for, and you can find those by just Googling 2022 ANSCO and the occupation name. Now, one of the issues that I was saying needs to be resolved is around the changes to those occupations, and it is more to do with the permanent residency program and the way that changes to the name or the codes may affect future permanent residency applications. I'll come back and discuss that in a bit more detail shortly. Occupation list is subject to caveats. This is intended by the department to allow them to prevent abuse of the immigration system. And they do this by stipulating specific requirements. For example, they would say that a chef cannot be in a fast food restaurant. Someone who's a customer service manager can't be in a frontline role. Okay, so customer service manager, for example, is intended to be for people who are developing policies around customer service and support and dealing with escalated requirements, not someone who's working in a petrol station taking your money. So the government uses caveats to limit where people can work, when they can work, what environment, what size business, this sort of thing. There were a few surprises when this was initially implemented. The government created a new caveat called Caveat 14 that basically said on the face of it, if you read it as a lawyer, that the only people who could apply were people specified under a free trade agreement. Okay, so Australia's got a free trade agreement with, Japan. If you were a sales and marketing manager, you could only be nominated if you were Japanese or Thai or Chinese or wherever the free trade agreement was. That caused a lot of stress for about 3 or 4 days before it was revealed that the department didn't intend to do that. And now all of the caveats have been removed. Caveat 14 has been removed from all of the managerial occupations. It does not apply to teaching, Megan. It only applies to yoga instructors, wushu coaches, private tutors and teachers, I assume for Chinese language, and traditional Chinese medicine practitioners. Okay, so caveat 14 was a big storm, but it was a storm in a teacup, and it was resolved within 3 or 4 days, thankfully. Although I think, I may have aged several years in those few days. Creation of caveat 16, that was added. It basically says you cannot, they've got a new occupation in there, accommodation and hospitality managers, not elsewhere classified. And they've basically said you can't be a brothel manager. Okay, so the point here is more that the occupation lists, even though they've only just come out a few days ago, they've already been revised, and they may well be revised again, okay, depending on pressure from industry groups and various others. One of the first changes under the 482 program in about 2018 was the removal of CEOs from the list. And you can imagine how long that lasted after the Business Council and others got involved. Okay, so there may still be future changes to the list. We'll have to see. The specialist skills stream, that's the higher tier stream. The primary requirement is for the position. I've used the word occupation here, but really it's the position that you're nominating must be remunerated above $135,000 per annum, and you must be able to demonstrate that the market salary rate is above that figure. Now, this is two different concepts. When you nominate a position, you have to say, this role is, let's say, a data analyst, and we're going to pay this person $140,000. You also have to demonstrate that that is what the market pays. Okay, so this is intended to prevent abuse in the sort of situation where you say, okay, I want to hire a barista and I'm going to pay them $135,000 because the occupation's not on the list, but I want to sponsor them anyway. You have to be able to demonstrate that it is normal within the local market to pay someone $135,000. If the market salary rate is below that $135,000 figure, then you're not going to be able to nominate under the specialist skill stream. Okay. You have to state an ANSCO code, but it does not have to be on the list of the CSOL list that is in place for the core skills occupations, and caveats do not apply. Okay, so if you're nominating an accountant, and for example, there's a caveat on accountants that says that the business must have a turnover above $1 million, but you're nominating a senior accountant, and you're going to pay them $140,000, and that can be demonstrated in the local market, then the caveat doesn't apply. Okay, so that's an interesting sort of get out of jail free card that kind of works against one of the core principles that they've tried to embed in that core skills program. Also, the specialist skills stream specifically excludes trade workers, machinery operators and drivers, and labourers. Okay. And the reason there would appear to be that, particularly for machinery operators and labourers, they are not available, generally because they're not considered skilled roles, although it's not unknown for people to be earning above that salary threshold because of fly in, fly out work or the type of remuneration that's received in the industry. There still will be pathways for skilled trade workers under the core skills stream. And for machinery operators and labourers, you're going to have to look at the labour agreement stream. But depending on where you're looking and what sort of roles you're looking for, that may not be an option either. So moving to the 186 very quickly. The 186 has two streams: direct entry, which requires a positive skills assessment and evidence of 3 years experience, or the temporary resident transition. Now, the temporary resident transition stream requires you to have worked for at least, sorry, I'll start again. The temporary resident transition stream has, until the 7th of December, required you to work typically for at least 2 years in Australia in the nominated occupation for your sponsoring employer. The government has varied that now by allowing applicants for the 186 TRT to include any work experience in their occupation on a 482 or 457 towards that 2 years. That's a fairly big change because for temporary visa holders, basically if you couldn't keep up that 2 years employment because you had a difficult employment relationship or whatever it might have been, the business went out of the business went broke, whatever it was, you would have to restart the clock and do your 2 years again. The goal of the government is apparently to get people through the pathway to permanent residency more quickly and to streamline that. But there's a couple of issues. Okay, firstly, there is not a great incentive for employers to support people through that TRT pathway before 2 years because the employer has to sponsor the person for the 482 visa in the first place, and then they have to pay a substantial amount of money to support the person getting permanent residency. The person, obviously, once they have permanent residency, has no tie whatsoever beyond the employment relationship with the employer. And so there's no great incentive to support people who want to apply for the TRT pathway before the 2 years. Okay, so that's one factor. We also have this issue now where the TRT pathway will not be available to that cohort who can't get to the 2 years in their occupation because the occupation is no longer on the consolidated skilled occupation list. It's probably worth clarifying here that under the previous system, pre-7 December, anyone who did 2 years with the sponsoring employer in their occupation could apply. Okay, you don't need your occupation to be on the list, the current CSOL, in order to apply for the TRT. You just need to have had a visa and worked in the nominated occupation. But if you can't get to that 2 years now and the occupation's gone, you won't be able to. If you can't get to the 2 years on the current visa, but your occupation is on the list, then you can renew the 482 visa, reach the 2 years, and apply with the support of the employer. There is some ambiguity, however, around the changes to these occupation codes, whether it is simply a like-for-like change, meaning that, management consultants had its code changed from 267.312 to 267.413, for example, and I'm just making that up, but for example, or whether it's because an occupation has been split. So, for example, you were an ICT security specialist. That occupation no longer exists because it's been replaced by 6 separate cybersecurity roles. So there are some ambiguities there. The department has indicated in writing that there is an intention to provide flexibility. But one of the things about immigration is that if the department is going to use its discretion in your favour, even though the legislation is perhaps not as favorable, that means that the department is actually going outside the letter of the law to do the approval. So if I, for example, apply on the basis that I've seen in policy that these two occupations are, relatively similar, or that the government's going to give flexibility around this, and I believe that my occupations are similar, I lodge the visa. The decision goes against me because the decision maker, the department, doesn't consider that they're closely related. Well, I've got no pathway, okay, because the tribunal and the courts are actually going to read the law more strictly than the department said it would. And I've just spent that money. I now potentially have a situation where I don't have an ongoing visa because I'd moved to a bridging visa for my permanent visa, and there's no appeal pathway and all sorts of things. Okay, so what I'm saying is that there needs to be a great deal of discretion used around this, and I would highly recommend waiting until further clarifications provided by the government in writing around what their intention is with this. The other thing that has been removed is flexibility across unit groups. So previously the requirement was simply that you had to have done the 2 years full time in an occupation or within a unit group. And what I mean by that is there are 8 separate registered nurse roles, but they're all considered closely related, and each individual occupation is in the same unit group. That's just the name. It's a unit group, and then there's subgroups, major groups, etc. That flexibility has been removed. It's unclear why. We haven't heard clarification from the department on why that's been removed, but it may affect some people. Areas that it might affect include IT, aged care, not aged care, IT, healthcare, nursing, medicine, and possibly a few others, bakers and pastry cooks. Okay. The other thing is that the 2-year requirement, because of that change that I mentioned before, where it's no longer about have you done 2 years with your employer, it's have you done 2 years on the visa in the occupation. The legal requirement has moved from the nomination to the visa. Okay, and that just has a few different implications. Relatedly, the employer is no longer required to explicitly state that they support inclusion of family members in the 186 application, because effectively the government's saying, well, it doesn't really have anything to do with them, and just removes a small barrier potentially. And also there is the potential for children over 23 to apply for and receive a 186 in the TRT stream, but it's a very, very time sensitive issue. If you have employees, or if you yourself are in this situation, do seek migration advice, because the 482 visa ceases the day before the person's 23rd birthday. So really the only option is to get the visa in prior to that birthday, which means you need to meet the requirements. And then the child needs to be added because they will lose their 482 and they need to get that bridging visa. Okay, so it's a sensitive issue, but it's a little bit of increased flexibility. Last point I'm going to make is that we do need clarification on some of these issues. The changing occupations around 186, that's probably the biggest one, but there are things that will continue to need to be identified and sorted through by the department. They've already implemented a whole bunch of these patches to the system, and it's hoped that they'll continue to do some, because it's a very difficult space to advise in when there's uncertainty around how the government will assess things. And, a comment, for example, in an explanatory statement that accompanies a legislative change that says additional flexibility could be provided for in policy is not going to cut it if your visa application is refused. So that's a summary of the changes to date. There will be more changes. We will be publishing more detailed information and sharing detailed information with clients about each of these things. We've spent the last 2 weeks updating documentation, internal quality assurance materials, to make sure that when we're looking at applications, we're taking all of these factors into consideration. And we're excited to continue to work next year with our clients to make sure that they can meet their local labour market requirements and continue to grow and prosper. I'll pause there for questions. I know it's probably been a lot of information, but I appreciate everyone's attendance, and I'll just wait to hear if anyone's got any further questions. I must say thank you for your acceptance of my coffee drinking during this session. It's been a tough couple of weeks just with all the changes from the government. It's not every day that this occurs. And I think the analogy that I've provided in the past is it's a bit like throwing a brick through a spider web where you've had years and years of legislative changes. And when something big like this happens, there's all of these threads get broken, and the government's tried to stitch them back together. But at the same time, they've missed some have been connected in the wrong place. And we spend quite a lot of time collectively as a practice working through those changes to try and make sure we haven't missed anything, because the last thing we want to do is give our clients advice that is then going to result in us falling through a trapdoor for some reason, because the requirements, you know, that have been put into legislation just simply either cannot be met, or they're not viable, or there's no provision for whatever situation it is. So thank you all for your patience. I know some of you have waited for additional time when you've sought advice or clarification from us. When can we affect the labour agreement stream of the SID to come into effect? The labour agreement stream is there. It's still operating as per the previous program. What we expect to see is that sometime in 2025, and this may only happen if Labor is re-elected, but sometime in 2025, they'll move more towards this union-oriented model where unions have a much greater say in the process and are able to set certain terms and conditions. So, for example, in the aged care labour agreement, there is a requirement that you sign a memorandum of understanding. The memorandum of understanding requires the sponsoring employer who's entering into the labour agreement to allow greater access of union representatives to their membership beyond what is normally allowed under the Fair Work Agreement. So union members would come in and they'd be able to give briefings to staff. They'd be able to do a variety of different things. As a result, quite a few of the larger aged care providers are not so much interested in moving down this pathway, but it is very much, from my perspective, an indication of the way that the Labor government wants to go on this, because it really does believe that greater union involvement is a key to addressing exploitation amongst temporary visa holders. So options really include apply now under the current program and hope that it comes through, or hold off, but the conditions will be much more based on your engagement with unions. Okay. If no one else has any further questions, I'll say a big thank you to everyone. Thank you for a wonderful year from Rome Migration Law. We will be putting out additional information in coming weeks about the programs and keeping people updated. But if I don't speak to you before then, have a great end of year. It's been wonderful working with you all, and I look forward to 2025. So thank you very much and have a great holiday break.